Hello viewers, welcome to our program on immigration and public affairs. I am your immigration attorney Michael Fulwani, and once again we have with us attorney Madhvi Samudrala. You remember last week you saw her on this same program and she gave you a lot of information on dreamers. However, today we want to tell you about certain important developments, new memos that have come and information that may be of help to you. To start with, one of the questions that used to come, still comes, is from some religious women especially when they have to go for photographs or fingerprints, and there is some reservation because according to their religion they are supposed to cover the head or cover their ears and hair maybe, and the question has been raised as to whether they can be exempted from the requirement of photo or fingerprints. Recently there was a memorandum issued by the Immigration Service, the Homeland Security. They said we cannot waive, means we cannot just say okay, photo or fingerprints is not required. You have to have a photo, you have to have a fingerprints. But they said we will be accommodating. We will be accommodating that if a person can cover a little bit so that at least is recognized, as long as the face can be clearly recognized, they may accept certain coverages like covering the hands maybe or the feet maybe, as some religions require that. So I think remember that if you are in that position, if you run into any problem when you go to the for fingerprinting and photos and they give you a hard time, you can always contact us and we can send you a copy of that memo that you can show to the officer concerned and tell them to comply with those regulations. Madhviji?
I agree with Mr. Fulwani that this is very good for individuals who wear a hijab, and it is very important for them to keep that head covering, and it's not right for us to tell them to remove that for the purposes of a photograph. And it's good that immigration is considering their religious beliefs and has come out with this policy, and I think this is really going to help out with a lot of our clients who are from those countries too.
Every year there is a lottery program. The State Department announces that this year you can apply from this date to this date, and then certain countries are not eligible to apply under the lottery program because the policy has been that those countries who are sending a lot of people on their own, immigration is coming in good numbers anyway, there is no need for them to get into the lottery program. So there are a number of countries which are not eligible, but changes have taken place. Once upon a time when they started, Pakistan was there, okay. India was not there. India has not been there from the very beginning, but for some years Pakistan was permitted. Then when they saw a lot of people coming from Pakistan in the normal categories, they dropped Pakistan out. Bangladesh was the biggest #1 country for all the applicants, to the extent that I am told that when they used to announce in Bangladesh you can get postage stamps, papers are gone, envelopes are gone. Millions of people applied. And so unfortunately they took Bangladesh out now. Anyway, so right now we have only the dates that Madhviji is going to tell you. We are still awaiting for the detailed instructions. We believe that most of the instructions with regard to the requirement of a higher education or 2 years skilled work experience and other things may be same, but once we have detailed regulations, we will come back on TV Asia and tell you more information on that. But what are the dates, Madhviji, for applying?
The dates for the DV 2014 program start on Tuesday, which is October 2nd, 2012 at 12 noon Eastern Time. The program will conclude on Saturday, which is November 3rd, 2012 at 12 noon Eastern Time. As Mr. Fulwani said, we don't have the instructions yet. Hopefully by the end of this month we will have the instructions. But like always, it would be an online application. No paper mailings are allowed. Also, there are no fees associated, no filing fees for the DV lottery program. Another thing the immigration has come up with is that they have asked the people who were selected for the DV 2013 program, they have requested that you keep your confirmation numbers until September of 2013, even if you were not selected, because sometimes it is possible that the people who are selected may not apply, and immigration may have certain more numbers to give out or visas to give out under the DV, and you might be one of those lucky ones. So this is what the immigration has told. The last thing I want to say on the DV program is this, that we have seen that in the past there have been emails and letters and which we have found out are fraudulent. So you have to be careful when somebody says, oh, you are selected, you get an email or a letter and it says you are selected for the DV program, please send in so and so money. Be careful of such scams, because these are pretty common when the DV program individuals are selected. This is something that happens very frequently.
Fraud and scams on the Dreamer program and the last program, and I'm glad that you mentioned again, be careful about the fraud and scams even in the lottery. But we see that happens all the time. I mean, there isn't a day that I don't get 1 or 2 persons whose cases have been completely bogged by some other attorney or an agent. Even unfortunately, I would say even some unethical attorneys have given wrong advice to people. They are not eligible at all. They say, don't worry, fill up the form, file a 130, even if there is no 245I there. Every day, Madhuji, I got this month only 4-5 cases where a lawyer told them, just apply, don't worry. When the labor cert was approved, I-140 was approved, and you want to go further, say, oh, but you don't qualify, you don't have a 245I. They said, why did you take my case? They said, well, things change, something like that. So be very careful, watch out who you seek the assistance from, and make sure that you go to the right person, an experienced immigration attorney, for assistance. I think it's a time for a short break, and let us take a short break and we'll be back, give you some more very interesting information. So don't go away, stay tuned, we will be back. The lottery program and other things. There's one subject that we want to talk about today which has bothered me personally for many years and recently, and Madhviji even also comments on this. We can talk about some things. This is about section 214B of the Immigration Act, and people don't understand obviously the section of the law, but many times when people go to the American consul in India, Pakistan, Bangladesh, any country, the American consular officer can make a decision discretionary, like he is a god, to give or not to give the visa, and simply deny. So this has been going on for many years. Obviously, at some point in the background, in the past, Congress did pass that. So the consular officer say, well, this is the law, I have to follow the law, and therefore if we believe that this person is not qualified, then we can deny the visa, and I tell them that is correct, absolutely. But look what was the intention of the Congress in enacting that section? What has happened over the last 30, 40, 50 years, 60 years? Are we still applying the same policy of applying for 214B? I am not saying the Congress has passed 50, 60 years ago, but whenever they passed under those circumstances, section 214B was put in so that there is no abuse by people getting a visitor visa, a student visa, or some other type of exchange visitor visa, come to the US, stay illegally and don't go back. It was happening a lot because things were so easy at that time. People used to come in, there's no 9B, no bars, no ineligibilities. They come in, apply for a labor certification, get a green card in 6 months. So from the word got around that it's easy, just go and somehow visitor visa, student visa, you can get a green card, go to Michael Fulwani, go to him, go to that. But that was abuse, and there in those circumstances the application was of 214B was understandable. But the things have now changed. Let me just say something. In the past and present, past was what I just talked about. What has happened since then? Presently, there is a technology. Over the years, the technology has grown to a level where today the American consular officer can go on the website, go on the database, The database is now so extensive, they are access to the immigration records, they have access to the CBP records, they have access to the Department of Labor, they have access to the Motor Vehicle Department, they have access to the Social Security Administration, FBI and all that. I think very easily, very quickly they can see the complete background of the person and then deny based upon what they think. That's not happening. What I am saying now, the Madhvi will comment more, that is it still appropriate for them to apply the same 60-70-year-old policy when 6-7 now today you have, supposing somebody comes and stays even one more day on a visitor visa, one more day, his 10-year visa gets cancelled. If a person stays more than 180 days, less than 1 year, 3 years bar applies. If he stays more than 1 year illegally in the US, 10-year bar applies. He cannot, he loses the status, he does not maintain his status, he cannot change from one non-immigrant category to another non-immigrant category, he cannot change, apply for a green card except 1 or 2 categories like husband, wife of a citizen, children of a citizen, parent of a citizen, there are exceptions. As long as they came legally, they can adjust their status even if they overstayed. But majority of the people, 80-90% of the people, if they lose their status, they came illegally, they won't be able, what are they going to do? I mean, we have seen, Madhviji will agree with me, I have seen, he has seen, I mean, I had cases where I was shocked, I was surprised, a big businessman, a person well settled, a person married with children, first time he applies, it gets denied 214B. He calls me, 214B, what is that? I say, because the consul is not satisfied, he thinks that you may stay back. He said, me, I am a film director. I mean, in reality, Madhviji, I am telling them, I had a case many years ago where one of the leading directors in south of India, he was coming to see the locations for shooting, and they denied him 214B. And I said, shocked, I cannot tell the name of the producer, you know him. He called me, said, Michael, what is happening? My director is denied. I said, that shouldn't happen. So I sent an email directly to the consul and saying, this is what has happened. And then I got a reply that, well, just, they don't say made a mistake, never. They say, oh, please tell him to come and reapply, come back. So obviously what I am saying, there has been so many instances, I can talk about 10 programs just on that. I mean, a person, remember we talked about a person who came here to donate his kidney to the uncle and the consul gave him a visa, one entry. He came in, the doctor said you have to wait for 2-3 months more before, because he has to go through heart surgery first. Okay, so he went back to continue his job and stay with wife and children. Why should he stay here? He got a call from uncle that I am fine now, doctor says you come. So he went back to the consulate. He says, okay, now I have to go. 214B. What do you mean 214B? 214B is applied when there is a clear and presumption that this person is likely to stay back and not come back. But look, he went in and he came back after a month. If he wanted, he could have stayed back. So many of those situations, we have some couple of instances of students that have been denied 214B, not newly applying, of course. Even newly applying, there are guidelines that they should look at the intention of the person at the time of application. Consular officer is not supposed to look in a crystal ball. Oh, if he is going to go study, he will complete the studies and not come back. That is not what the 214B is. 214B very clearly says consul must look at the intention at the time of application. So not look in the crystal ball. Yeah, of course, at the time of application, they see the documents, papers or anything, and they make a determination based upon facts that this person will be, maybe some understandable thing is. But today, people go for application, they don't talk, go to the window 2-3 minutes, ask now what's your name, why you want to go, okay, denied. That's it in 1 second. He says, oh, a lot of papers I brought, documents I got, certificates I got. They say, listen, we don't have time, we don't look at any papers. There's just a 1 minute, 2 minute interview, 214B. I think 214B has been heavily abused, and there's about time that the Congress either makes a change in the law or the administration makes in a policy. As a policy authority, they can give proper guidance to the consular officer to apply 214B under such and such conditions or such and such circumstances. Madhviji. Student, you had some one or two.
We were just discussing just before the program with Mr. Fulwani, and yes, we have some interesting cases about students who were studying here, went back to India for a vacation or something like that, and then they have only 1 semester left. So because their visa was running out, they went and applied for a visa. Unfortunately, the consulate tells them that, oh, you're ineligible under 214B, which we think is not correct, because this person has studied 3 years, has only one semester left, and then just wants to come back to the US to complete the one semester so that they get their degree for all the work that they did at 3 years. So these are some instances. There have been memos which we are trying to point out to the consulate about those memos, so the consulate can reconsider such cases. But as Mr. Fulwani said, yes, there has to be some legislation to this 214B issues, because from the time that it was implemented until now, there have been so many changes and so many new sections, new sections in the laws, and which are covering all the periods, all the provisions of the law with regard to people who tend to overstay in the US, that they should be a little, and especially we have observed with India, they are more stricter than the other countries, where other countries we have found lenient, but in India, the 214B, the standards are not across the board, and they apply very strict standards on such cases.
The under 214B, the guidance or the understanding was that if the council believes that this student really is using this student visa, he's getting a student visa from us and will go to US and never go to school, he'll go and work illegally. Okay, understandable, but that also should be applied based upon some factors, not just the case. Anyway, but in the instance that you said, the student came in, she went to school, 3 years. 3 years she went to school, the last semester, 3 months remaining, father got sick, so she just went to meet the father and vacation maybe. And then she thought to go to the consulate and show them, and he put a stamp on the passport. Consul says 214B. I don't know where the 214B is coming from here. Sorry, I got very excited because this is a subject I get very excited. But I think it's about time for another break. And right after the break, we will continue further. So stay tuned, we will be back. Welcome back. Madhviji said that she wanted to remind you about the applications for deferred action for those youngsters that came under the age of 16 when they came to the US and have been here for 5 years. They are not over 31 and they already started accepting the applications. Madhviji, you want to remind them again?
Yeah, with regard to deferred action for childhood arrivals, yes, as I said, August 15th was the first date the immigration started accepting applications. You have 3 forms to be completed: the form I-821D, the form I-765, and the form I-765WS. So, and the fees that you have to pay is $465 in favor of US Department of Homeland Security. For people living in the tri-state area have to mail out their forms to the Chicago lockbox offices. So, and we already discussed the other information in the last programs. If you have any questions, please feel free to email to us, and if it's a general question, we can answer by email, or we may ask you to do a consultation with our firm to go into the further details of your case. Now, since Mr. Fulwani was getting so excited about the previous F1, I just was asking him whether he can share with us any other interesting situations that he has come across in this entire 35 to 40 years of your practice in immigration law. I know there have been a lot of changes.
And hundreds of stories, and most of them are real. One thing I cannot do is to mention any names or references, because there are stories even about maybe film production companies, stars, VIPs, big people, ministers, whatever you call it, hundreds of them that I cannot identify. And recent ones, of course, I won't talk about anything, but something that happened 25, 30 years ago, very interesting things I'll tell you. And I'll tell you the story, and then you tell me as an immigration lawyer, what will you do? So here is a very interesting story. I got a client who came for a consultation. It's with uncle and his nephew. He said, we have a problem. I said, what is the problem? He said, my nephew in India, he got married to a girl, a US citizen, and she filed papers for him, and he got his immigrant visa in 5 months at that time, and then he came to the US. He came to the airport, and his wife's uncle was there, his own uncle was there, And he saw them and he says, "Where is my wife?" Silence. "No, where is my wife?" "Oh, she is in a hospital." "Oh my God, what happened?" He says, "Oh, she delivered a baby boy." He said, "Baby boy?" He said, 1, 2, 3, 4, 5 months. "Oh, I got married 5 months ago. How come a baby boy come?" Then uncle said, you come, tonight you come and stay with me. I'll explain you everything. He took him home and he told him that you probably don't know that she was already having an affair with some guy, some non-Indian, whatever other community it was. And the parents took her to get married to hush up the whole thing. And that's what happened. So he says, "My God, this is CR1. He had a conditional card for 2 years. And the parents of the girl and everything apologize, but now he's in a fix, right? He said, "What shall I do?" "I'll tell you further what shall I do now. You come in as an immigration lawyer." You're sitting, he said, "What shall I do?" He has a conditional status, 2 years, and is completely confused. Obviously, a fraud is committed with him. Now, I asked him, how come? She was 5 months pregnant, 4 months, you didn't even know? He said, "No." I said, "Okay."
With regard to this application, as a lot of you know, that if you get married to a US citizen and you get your green card within 2 years of your marriage, usually you get a 2-year green card, because this was implemented because there was a lot of marriage fraud in the past, and immigration wanted to make sure that this marriage is genuine. So they usually issue a 2-year green card, and before your 2-year green card expires, then you need to apply for a 10-year green card. If you're still married, there is no problem. You have a lot of documentation to provide to the immigration, and you can provide that. But if there's a divorce or if there is a separation, then you have to prove that your marriage was genuine. It was not for immigration purposes. So the first thing, of course, this person has to do is, would have to file a condition removal I-751 petition, which is removal of conditions on the green card. To file the I-751 based on separation or divorce, you need to have a divorce certificate, which means that if he's not interested in continuing with his wife anymore, the first action is to file for divorce in the US. This is going to be a little tough case also, because he doesn't have any documentation to prove that they were living together, which is what immigration looks at in cases of divorce or separation. So it's going to be complicated, but I don't know, an immigration officer might even be sympathetic to a situation, which we don't know, but depends on a case-to-case basis. But in this case, since he does not have the documents, it looks a little difficult.
I'll tell you what happened, but before that, something else. I said, "So I will take care of your immigration problem." He said, "There's one more problem." I said, "What is the problem?" "That child that is born has my name as the father." I said, "For the rest of your life, you got to support him. He's your son. You're a child." So that was another legal issue. And I got him an attorney who went to the court, and he got a paternity suit, and they agreed to that, and he got out of that problem. On the question of the waiver, we were lucky, and also we made a very good presentation. He has a lot of photos, pictures, bona fide. I mean, he did not know anything. She committed a fraud with him. That's the thing. But on his own, it was a real marriage through the parents, through the family, Patel family, 1,000 people. And immigration officer was a lady. And she got very upset. How the hell can she do that? That's not fair. That's what we are saying, the same thing. It's not fair. This guy was a victim of this fraud, and it's not his fault. So then she was kind. She approved it. It was done all the way in the world. But I mean, these cases that come in, sometimes they are so complicated, complex, interesting also, obviously. Okay, another story, and I may not have much of immigration angle, but see what happens is this. Same thing. This girl was a citizen. She got married to a boy there. The boy comes in, and she let him stay in his home for some time, and then he finds that there was some guy coming in, a boy here, and he told her, "You to go and sit outside, and she'll be sleeping, and he'll be sitting next to her on the bed, and like she said, I had a headache, and I just told him to press my head." He said, "But I'm your husband. I'm just outside. Why don't you tell me? Why should anybody come?" I mean, understandable culture. And she says, "You are idiot. You have to understand the culture of here. This is America. This is not Gujarat here."
Yeah.
Right? It's a culture. Basically, in America, you have to do what Americans do. I mean, I'm born here, an American citizen. He's my boyfriend, was before the marriage. So that means I should disconnect all my friends from here. So this guy stayed still more long, and then of course that he saw increasing. She will come 11, 12 o'clock in the night, parties and all that. There was an immigration angle also there in a way. They came to see me. That's how I came to know about what happened here. So I told them, but that's a decision you have to make. In many cases, when people come like that, I say whether to do the reconciliation, whether to separate the marriage, divorce the marriage, that you have to make a personal decision. That's your life. As a lawyer, I can help you on the legal issues, but I cannot tell you when to break, when to make. So then he came back again and they says it's not going to work, and that's the end of my story. So we went through the divorce process, and again he was lucky. I mean, at that period, 30 to 25 years ago, it was not as difficult as it is today. So they approved the CR, and then he got his green card. So there are a lot of, I mean, just interesting. There are so many of these situations where we have seen that they get married in India, they come in, and then after very few short period of time, marriage breaks and there are divorces. The children, when they are involved, is even more complicated. But all I can say, just think carefully. Whatever you are doing when you get married, make up your mind, spend some time, make a proper decision so that these problems do not happen. But they have happened in the past. Some problems are going to always happen as long as they are husband and wife and their marriages become and marriages break too. But immigration consequences must be taken into consideration.
Very, very interesting. I know Mr. Fulwani has a lot more to talk, but we are running out of time. So we hope to see you next Saturday again. David Nachman is going to be back on this show next Saturday, and I'm sure he has a lot of things to tell you about the recent immigration changes and policies.
And maybe I'll think of some more interesting stories. So from time to time, whenever we have a program in which we have extra time like this, we can tell you about these stories. In the meantime, we thank you, Madhviji, for being with us, and all of our viewers for watching the program. If you have any questions, comments, suggestions, if you need any assistance, you may contact us, and we'll try to do our best. Thank you very much for watching the program, and goodbye.